On this morning's Ag Issues program, a pleasure as always to bring to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine. This cool weather has been great.
Oh, absolutely. And plenty of rain up at your farm?
We got, let's see, I think out of the most recent rain, when you combine a couple days together, was about 1.4 inches. So that's pretty good. It was timely, too.
Yeah, absolutely. All right, let's get to it. And the first case we want to talk about actually is something we have mentioned before on this program. And this is up in the state of Minnesota, but a lot of it has to do with their farm protection law, and that law was upheld in this case.
Yeah, and we've got the remand decision on this now, which I'll get to in just a moment, but very important decision. And if we've got any legislators that are listening in this morning, I think this is a lesson, particularly coming out of the remand decision, for other state legislators to listen to and pay attention to because of what the court said on the remand. But just by way of review, so people know what we're talking about here, it was back as a result of the farm debt crisis in the 1980s. In 1988, the Minnesota legislature directed the Department of Agriculture there to come up with a study of the issue of ag contract production and recommend to the legislature how it might provide additional protection, both legal and economic protection to contract growers. That was perceived as a significant problem in numerous states, not just Minnesota, but Minnesota is known for contract poultry production as well as hog production. And they were seeing some abuses with respect to, perceived abuses, let me put it that way, with respect to those contracts. And so the task force came up with a recommendation, and the legislature did pass a producer protection law. And this was back in 1990. And the new law, the legislature made some important statements, not just in the statute itself, but building a good legislative history behind it. And they declared that it was the policy of the state of Minnesota that certain financial protection be given to producers on farms, small producers on farms that are producing under production contract. And, of course, you've got the technical definitions throughout the statute of who a contractor is and who a subsidiary is, who a parent company is, what a wholesale produce dealer is, what a person is. So they were very specific as to who was covered by the contract.
And, you know, as you mentioned, going clear back into 1990 overall, and this case has had plenty of tails. Looks like 2017 was more of the specific year of obviously the decision that we see now that has come out concerning this case.
Yeah, this case started in 2017. You had some of the defendants in the case that entered into chicken production contracts with a major supplier to grow chickens in exchange for monthly payments and bi-monthly bonus payments. And that company got bought out, so now we've got a subsidiary, a successor company, let me put it that way, of the company that the producers, the farmers actually contracted with. And it had out-of-state headquarters. It was incorporated in Delaware and then headquartered in California, but they're dealing with Minnesota producers. And this is a key point, particularly, again, I want to emphasize if legislators are listening here. So you're doing business with a company that's not anywhere close to Minnesota. It's headquarters in California. It's incorporated in the state of Delaware. And the Pittman Farms, which was the plaintiff in this case, owned more than half of the new company that had bought out the assets of the parent company. So you got all types of ties in here. It was extremely vertically integrated. And then they bought membership interest and became the sole owner. Well, in 2019, the successor company to the original company that had bought out the membership interest got into financial trouble, and they ceased their processing activities. And they told all the farmers that had signed these contracts, we're going to cut you off. We're going to terminate the contracts effective in 3 months. And the farmers well, actually, it was the company that said we're going to terminate the contract, made demand for payment in excess of $6 million from the farmers for breach of contract. They claim the farmers had breached the contracts, although they were in financial trouble. And so this ends up in court. And long story short, the Minnesota Producer Protection Law was upheld. And on remand, Greg, this is what I want to emphasize. Now, the farmers had lost in the trial court. They won it at the appellate court in the Eighth Circuit, and it was sent back to the trial court to render an opinion consistent with the appellate opinion and figure out what the damages are. But one of the things that the trial court said on remand was, the farmers here in this litigation are all in Minnesota, and the ag production contract had a choice of law provision in it that would dictate a different location. Different rules would apply other than the rules in Minnesota. But the court said, we're going to ignore that because the contract was with Minnesota producers. The assets involved were all Minnesota assets. And so, therefore, Minnesota law applies. And I think that is a very important finding for states that adopt similar legislation to this, where these companies try to say, well, farmers, you're going to be governed by the laws of the state of California, the state of Delaware, and we've seen in the Proposition 12 case how California is dictating agricultural practices elsewhere. Now consider this one. This did have a choice of law provision in it, and the court said, no, you're dealing with producers in Minnesota. We've got a producer protection law in Minnesota under Minnesota law. The assets involved were on Minnesota farms. Minnesota law applies to this. We're going to disregard your choice of law provision in the contract. That's pretty important.
Does this situation arise often in this case? And thus, as you mentioned about emphasizing this to any state legislators that are listening, they could see, well, this case did happen or this case happened. Or is this unique to what we've seen in other court decisions?
Well, ag production, that's a good question. Ag production contracts are prevalent, particularly in the poultry industry and in the hog industry. They're also used heavily in the fruit and vegetable industries, too. Not much in cattle, but in some of the grain. But when you have a producer protection law like this that is specifically adopted by the legislature with provisions in it and then supported by legislative history that says this is our policy to protect producers that are growing agricultural products under a production contract, our policy is to provide contract protections for them. Then when you get into a supplier contract like this, where they've got a choice of law provision in the contract that says, no, if there's a dispute, it's going to be governed by the law of California, the law of Delaware, somewhere else. The court says, no. One, we have a producer protection law. Two, the farmers involved were in our state. Three, the assets involved in our state. Our law applies. That's a big deal, and that's the key point here. So there aren't very many other states that have producer protection statutes like this, but the principle on remand overriding a choice of law provision that the supplier had written into the contract based on that state's law, their producer protection law, that's the key point that other states could pick up on and utilize.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is joining us on the program. Roger, the next case we're going to talk about involves Chapter 12 bankruptcy planning, and this specifically is looking at can you modify your Chapter 12 bankruptcy plan, and what would be the criteria of your ability to be able to do that?
Yeah, the short answer is yes, you can. Chapter 12, of course, is for family farmers, and specifically only for family farmers. And again, Greg, this is another one of these legislative things that came out of the 1980s farm debt crisis. Chapter 12 came on the scene in 1986. It became a permanent part of the bankruptcy code almost 20 years ago, but up until 2005, it hadn't been a permanent part of the code. And so thankfully in 2005, Congress changed that. But when a farmer gets into Chapter 12, the law allows them to modify their plan. Of course, this is a reorganization section of the bankruptcy code. It's not liquidation, and so you have to put together a reorganization plan. Well, when you do that, if you have trouble meeting your payments under the plan, can you come back in and modify the plan? Of course, your creditors are probably going to object to that. They don't like that. And the issue in this case out of Iowa, southern Iowa, was how many times can you modify your plan? And we'd gotten into a third and fourth proposed modified plan here, and the creditors were claiming, well, you have to show that your circumstances have changed. And that was the issue in the case. And the court said, yes, this is the bankruptcy court, Southern District of Iowa. The bankruptcy court said that the code does require the debtor to show that circumstances has changed, and there has to be a substantial change in circumstances for you to redo your plan, but that the farmers had met that requirement in this instance. Now, they were on their fourth modified plan, the fourth time they'd gone back in and requested a change. And so, they had enough evidence to be able to do that. But the point is, I think also the message to make out of this, and the point is that you can't always go back in and change your plan. You can't just say, well, yeah, the court approved the plan, but we don't like it, and so we want to change it. No, you do have to show that your circumstances have substantially changed, and that could be weather issues, that could be other types of issues that are out of your control, could be a crop failure, could be insect manifestation, all types of things. But you're going to have to show substantial changes that are preventing you from meeting your plan so that you can get it modified.
All right, next case we want to talk about, I believe, involves a Kansas veterinarian. In this case, a veterinarian's lien that failed for lack of proof.
Yeah, if you're a creditor to a farmer that ends up in bankruptcy, again, this is another one of these bankruptcy cases involving a farmer, and you want to assert a lien, you've got to prove it. And Kansas does have a veterinarian lien statute so that a veterinarian who renders services to animals can get paid. And you have a prior perfected lien, what the law says, you come first in front of a prior secured creditor of that farmer. But you have to prove that your lien was there. And the vet couldn't do that in this case. He could only establish that, and it was a weird set of facts. These animals of the debtor showed up at the vet's office, these cows. This was a Flint Hill ranch situation. And these cows show up at his office, the veterinary clinic. And so he renders services to them. He's done this in the past, so he knew whose animals they were. That's not a question. But then there was some question because the rancher was feeding cattle for somebody else in terms of who authorized the cows to be there, who took them. He said, well, I saw the truck and trailer drop them off, but I'm not really sure whose truck and trailer that was, but I do identify the animals, so I'm assuming they need help. He did render veterinary services. You get up close to $20,000 in vet services. He wants to get paid for that. And the debtor said, I didn't take them there. I didn't authorize those animals to be there. And nobody really knew who did. And the court said, well, the vet couldn't establish that the debtor requested his services, and the vet failed to meet his burden of proof by a preponderance of the evidence, and so the lien was invalid. And the bank in this instance, the financier of the cattle operation, is going to win. They're going to get paid in front of the vet. But again, the point is, if you can establish that you've got a valid lien, you're going to jump ahead of prior perfected creditors, and the vet couldn't do that in this instance.
All right, Roger, as we move on, one of the things we want to look at, too, CAFO rules, the confined animal farming operations, and in this case, it was a court that vacated the medium-sized CAFO rule.
Yeah, that's right. This is a case brought by a farm organization, again, that was created out of the farm debt crisis in the 1980s to provide assistance to smaller-sized farming operations, and they're acting on behalf of various types of groups. And they challenged an Obama-era rule that came through the USDA and the FSA, and that rule exempted medium-sized confined animal farming operations from environmental review for FSA loans. If you're medium-sized, you don't have to go through any of the environmental rigmarole. We're just going to go ahead and you'll be able to get a loan through FSA. That came in the Obama administration. And now medium-sized CAFO, remember, that is exempt from environmental checks on this would be one that could house up to 700 dairy cows, 2,500 55-pound hogs, or up to 125,000 chickens. And so there were other farmers that challenged this, including groups out of Iowa, for example. This case actually it was in the federal district court in D.C. because USDA is involved. But there were a lot of farm groups in this part of the country that were plaintiffs in this case. And they said, well, this violates the National Environmental Policy Act. And the court said that it indeed did. And so they vacated that rule. And so the FSA conceded that, look, we didn't make any finding with respect to environmental impact. We just gave these size CAFOs their loans. We're not looking at any environmental issues. And the court said, no, you have to do that. Your rule is invalid. So the rule was vacated. It's been remanded back to the FSA, and they're going to have to write a new rule.
And the last case we want to talk about concerns a feedlot operator, or in this case, for the feedlot operator concerning domesticated animal activity. The Domestic Animal Activity Act, it doesn't provide immunity for the feedlot operator.
Yeah, this is an Iowa statute, and Iowa has had a number of important cases involving this statute. And what it does is say, basically, if you're attending a rodeo, a fair, some type of animal activity, and you have a guest that is injured, you can't be sued. You're immune from liability in those types of situations. Well, what we had here was a feedlot operator who discovers that he's got a downed heifer, and so he calls his neighbor. And his neighbors helped him with down cattle, as the court said, half a dozen to a dozen times in the past. And the heifer was down in an area where they couldn't get any equipment in there to help her get up, so they had to do it manually. Well, trying to get her to her feet, the plaintiff's leg was severely injured, and so he sued his friend, his neighbor, for negligence, probably his ex-friend now. And the owner of the heifer said, well, you can't sue me. This is a domesticated animal activity, and I have immunity under Iowa law. The court said, now, wait a minute. Trying to help a downed heifer get up is not a domesticated animal activity as defined by the statute. This isn't like a rodeo or a livestock show or a fair or something like that. You're just trying to get an animal up. And so the statute had a specific list of definitions as to what was covered, what is a domesticated animal activity. Standing up a downed heifer was not in that list, and so he did not have immunity. Kind of an interesting case.
And Roger, I want to give you an opportunity here because, unbelievably, as fast as the summer is going, you're less than a month away from a couple of seminars you have next month.
Yeah, this is a really big conference out in Coeur d'Alene, Idaho. It's a twin track, 2 days of tax, estate planning, business planning, and simultaneously 2 days of agricultural law topics like we talked about this morning. And this is co-sponsored by the Idaho State Bar Association, the Ag Law section of the bar out there, the Real Property section, the tax sections, and the University of Idaho College of Law and the University of Idaho College of Agricultural and Life Sciences. And so this can be attended online. You don't have to go to Coeur d'Alene, although if you've been there, Greg, that's one of the most beautiful parts of the lower 48 states. But you can attend online. I would encourage even farmers that are interested in this, but definitely their attorneys, their CPAs, their tax people, to attend this either in person or online. But I would reiterate, even farmers and ranchers on particularly the ag law track, but maybe even the tax track would be interested and would find this beneficial to their businesses.
All right, and if people have any questions or want to get a hold of you, have questions specifically for you, how can they do that?
They can reach me by email, which is roger.mceowen@washburn.edu, and then all this information we talked about is accessible either on my blog or on my website. The registration information for Idaho is on the front page of my website, which is washburnlaw.edu/WALTR. And then I'll be posting a blog article later this morning on what the topics we just talked about. And that's accessible through the homepage of my website. There's a link that'll take you to my blog.
All right. Roger, as always, very much appreciate it. Thank you very much.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the Ag Issues program here on 580 WIBW.